Thank you, Mr. Chair and members. I want to begin by accepting the amendments as suggested by the committee. This bill, AB 715, is a minor technical bill that clarifies the definition of accessible space in order to ensure that all school districts and building officials across California interpret the developer fee law consistently. Under current law, detached accessory structures are not assessed, and the goal of AB 715 is to ensure that a bike storage is not assessed as habitable space. Similarly, walkways are not currently accessible space, and my bill states that putting a cover on that walkway should not change that outcome. The opposition has been concerned that interior hallways would no longer be accessible space. That is not the goal of this bill. The committee amendments have helped clarify and alleviate the opposition's concerns. To be clear, this bill will not change the amount of developer fees collected. This bill simply clarifies current statute, and it follows the original intent and spirit of the law. With me today is Sean Topekian on behalf of the California Apartment Association.
Mr. Chair and members, Sean Topekian on behalf of the California Apartment Association. We are in support. We too want to thank the chair and the committee staff for working on the amendments and significantly narrowing the scope of the bill. AB 715 now is simply intended to clarify existing law. Under existing law, a walkway is clearly exempt. This bill would simply say if you put a cover on it, both covered and uncovered walkways would continue to be exempt. Developers put covers on walkways in order to accommodate for ADA standards, as well as make it more convenient for tenants who live in the apartment community. In the same way, current law exempts detached accessory structures. This bill would clarify that a detached bike locker is also exempt, very similar to a detached accessory structure. Many new apartment communities today, particularly in urban communities, are adding detached bike storage. These communities don't have room for traditional garages, and more tenants are utilizing bikes. The clarification in AB 715 will encourage developers to build these types of structures. This bill is not intended in any way to change what is assessed within the interior of an apartment. We have here with us today John Yeager, who works with apartment developers on school fees and can answer any technical questions you may have. Thank you.
No other witnesses. Any others in support? Any opposition, please come forward. If you could just make some room for the opposition. Oh, there is room. Okay, there we go.
Mr. Chairman, members, Jeff Frost, representing the Orange County Department of Education. Let me start by thanking the author for his comments that this is designed to be a technical bill. Let me also thank Ms. Kwong Kim for the huge number of hours that she has spent discussing this bill with us, with the sponsors, with the author's staff. Both the analysis and the language that's been presented in terms of amendments, I think, do clarify the walkway issue. The concern that we still have is the detached bike storage locker, which under this bill has now become a term of art. We don't see how it's any different than detached accessory storage, which has already been in the law for some time. Our concern is whether there's confusion or clarity regarding bike storage lockers within the perimeter of the structure. We're not sure that that's clear in the bill. That remains a concern for us. Thank you.
Mr. Chairman, members, Tom Duffy for the Coalition for Adequate School Housing, the CASH organization. We've been involved in developer fee legislation for about the last 3 decades. And when we first saw this bill, we said, what's the problem that we're trying to resolve? And it appeared to be a moving target. I have to also compliment your committee staff for really trying to shepherd this into something that is more definable. We'll remain opposed to this bill at this point in time and continue to work with the author and his staff and the proponents. But what we want to identify is that this is really trying to do something with developer fee law when there are many other things that if we're trying to change, we ought to consider other issues that are important to school districts, for the very reason that school districts today are in want of capital dollars. There's no state bond money at all that's left, and we do not want to have anything that would be an impediment to them accessing fees as we've understand them to exist for about the last 2.5 decades. Thank you very much.
Thank you. Any further opposition?
Roacho with the California Association of School Business Officials. Just want to align my comments with Mr. Frost and Mr. Duffy, also in opposition.
Nancy Chaitis Espinosa with the California School Boards Association, also in agreement with the speakers you just heard, and we ask for your no vote. Thank you.
Thank you. And again, Mr. Daly, I just want to confirm your intent is to clarify existing law, not change anything that is accessible or not accessible or not accessible, correct?
Yes.
Thank you. With that, any further committee comments? Mr. Thurman.
Well, it's just a question. It just seems to me that even if if we say clarification, that it would be changing the law in the sense that it's changing a practice.
Mr. Thurman, some districts interpret it one way and other districts interpret it another way. That's the need for the clarification.
I agree that there should be clarification in how it's applied, but if I understand it, it does mean that clarification will also mean ultimately that certain structures cannot be counted towards a developer fee, which will have less revenue, which is a change in practice, a clarification and a change in practice, which seems to me a change in practice for sure. To me, a change in law.
I think part of the background, sir, is that design is changing to accommodate the demand, what tenants want in buildings and so forth, like bike racks, covered bike racks, for instance. And so as the marketplace changes, has changed, different districts are interpreting the current language in different ways. There are technical experts here who can answer questions.
And I think it's fair. If it's not habitable space, then it shouldn't be. It shouldn't fall under the statute. It just seems that it does change practice. But if you had something if your witness wanted to add something,
that's why I agreed to carry the bill.
Yes.
Mr. Thurman, I would say that the distinction is that a bike storage locker is no different than a garage, no different than a detached accessory structure. A lot of apartment communities today don't have garages, and that's the intent of having a room where you can put your bike instead of a garage.
Mr. Chair, just so I understand it, I'd like to ask the witness and the opposition if we should expect that after this clarification there will be clarifications to all the things that you just mentioned, sir.
Well, Mr. Thurman, that's exactly our concern. That's why I made the reference to the different types of detached storage. This is now an additional one. The proponents of the bill say that it's no different than a garage. But under current practice related to the Uniform Building Code, everything inside the perimeter of the structure is accessible. It's not livable space, it's accessible space. And that's where the issue of, well, it's a garage, yeah, okay, is it external or is it internal? Same thing with a closet or now a bike storage locker. We are concerned that this does change practice.
So when you all say bike storage, you don't mean in a general area, you mean within the unit?
No, absolutely not within the apartment unit. We believe all items within the apartment unit should be assessed.
This is a common area?
Yes.
Got it, thanks.
Any further committee comments? Seeing none, you may close, Mr. Daly.
I appreciate the questions, and I respectfully request an aye vote.
Been moved and seconded. Secretary, please call the roll.
The motion is due pass as amended. O'Donnell?
Aye.
O'Donnell, aye. Chavez? Kim? Aye. Kim, aye. McCarty? Santiago? Thurmond? Aye. Thurmond, aye. Weber? Aye. Weber, aye. 4 votes.
The bill is out.
Thank you very much.
Thank you, Mr. Daly. With that, we'll go to Mr. Gibson, file item number 4, AB 709. File item 4, Mr. Gibson. You may proceed.
Thank you very much, Mr. Chair. and members, thank you for allowing me to present AB 709, which seeks to require charter schools to comply with the same transparency and accountability laws of traditional public schools. This bill will require the charter schools explicitly comply with the Brown Act, Political Reform Act, the Public Request or Records Act, and Government Code 1090. Current law gives broad authority to charter schools and exempt them from having to comply with a majority of the laws that applies ununiquely to school districts. However, this requirement of this bill currently applies to various public and private entities and beyond the scope of the intended charter school exemption. Given the fact that these charter schools are publicly funded, and at least we can do is ensure that our children are educated by institutions that operate under the law to ensure sound government. With me are representatives here who will provide testimony to this fact.
Mr. Chair and members, Seth Bramble here on behalf of the California Teachers Association, proud to co-sponsor this important legislation. Charter schools are public schools, as the Assembly member mentioned, that were established with a promise. We will give you the freedom to innovate, and you will show us results. Like lighthouses, charter schools were an area that we could look to perhaps to see some kind of change in policy that might benefit the entire system in terms of public education. I attended a meeting in Oakland several years back, and was excited to hear from the director of Charter Schools Division at Oakland Unified about a system he called knowledge transfer, where the principals at charter schools and the principals at traditional public schools would come together and they would share best practices, and that's what was intended here, to talk about lessons learned, and we don't do that enough. But the people cannot learn, we cannot learn from this innovation if this kind of business is conducted in private. What we didn't intend in establishing charter schools was that we would give a charter school total authority to do whatever they wanted with the tax dollars that they receive. The establishment of charter schools was not us, the public, yielding control to the agencies that serve us. In fact, we insist on retaining control and on staying informed. Having private and secret meetings to discuss how tax dollars are being spent is not innovation, and in fact, it's resulted in quite a few horror stories. I have with me Kyle Surratt from the Center for Popular Democracy to discuss a report put out in March of this year that outlines more than $81 million of fraud, of waste, of abuse of tax dollars by charter school operators to date. But to talk about, and that's in this state, but to talk about how frequency this is occurring, I did kind of a quick Google search about just since the release in March 2015 to now. So I'm talking about the last 2 months, and found 7 additional instances. Happy to walk through those if you guys desire. But what this bill is saying to charter schools is, by all means, do what you want, but do it out in the open where everyone can see. That's why we're talking about open meetings. That's why we're talking about public records. What this bill truly is saying is dream big and think outside the box, but don't abuse the public trust and spend that money on our kids, spend it on our students. We urge your aye vote.
Chair, members, my name is Kyle Surratt. I'm with the Center for Popular Democracy. I'm Director of Education. We're a national organization, but we have members in close to 30 states. So California is invested in charter schools in a very big way, and that's from a growth perspective. 63% growth in student enrollment just over the last 8 years. And this investment has not been paired with a strong investment in oversight. And this is a problem not only found in California, but it's found in pretty much the 43 states that have approved charter school laws within the United States. And so we have here in the United States a national charter school fraud problem, but in California is the largest contributor to that because this is the largest market where charter schools exist. So the question becomes, why is there a fraud problem here within California, $81.4 million in fraud? And the result tracks to the 1992 law that was passed. It was since updated a few times, but the problems within the charter school law allow for fraud to exist. And there's two major problems with the law that allows for fraud to exist. Number one is that there are poor external controls for charter schools. So at this time, there are no regularly scheduled audits of charter schools. Over the $3 billion that goes to charter schools every single year. So there's no regularly scheduled. Someone may request it, but there's no regularly scheduled audits that are done on a state regulatory level, right? They have privately scheduled audits. Number two is there's an internal problem. Board of directors are in charge of setting the internal controls of charter schools. And internal controls are what prevents fraud, waste, and abuse from happening. And there aren't enough standards in place for board members to set appropriate internal controls within their respective charter schools. So what AB 709 does is gets us closer to where we need to be in California, to improving the charter school law so that we see fewer instances of fraud, waste, and abuse within the system. Thank you.
Thank you. Did you have other witnesses? Or
No.
we have an opposition? Is that what they are? Okay. Okay. Oh, they're just okay.
Support. This is support.
Others in support.
Mr. Chairman, Jeff Frost, representing the California School Boards Association. Okay. We were a co-sponsor of this measure last year. We're proud to support it.
Mr. Chair and members, Aaron Evans Feudum here in support on behalf of the Association of California School Administrators, the School Employers Association of California, as well as the San Francisco Unified School District. Thank you.
Thank you. Others in support, if you just state your name, affiliation, and your position on the bill only.
My name is Jen Shilen. I am a charter school teacher. I support this bill.
Enrique Roacho with the California Association of School Business Officials in support.
Kathy Hall, the California State PTA, in support.
Thank you, Chairman and members. Tristan Brown with the California School Employees Association here in support.
Ron Rapp on behalf of the California Federation of Teachers, speaking in support. Thank you.
Liz Guillen for Public Advocates in support.
My name is Claire Haas. I'm with the Alliance of Californians for Community Empowerment, ACE Action. We worked on the report with the Center for Popular Democracy and in support.
Peter Manette, kindergarten teacher from Nevada County, in support.
Pat Mazzulli, high school science teacher, Fontana Unified, in support.
Jody Dayberry, Lake Tahoe Unified School District, in support.
Carla Zazula, Lake Tahoe Unified School District, in support. Thank you.
Dale Kennedy, Kings Canyon Unified School District, in support.
Okay, any in opposition to the bill? Please come forward.
Good afternoon, Alejandro Sandoval with Ed Voice in opposition.
Mr. Chair and members, Rand Martin on behalf of the California Charter Schools Association. I just have to say, wow, the last support statements were very surprising. I didn't realize that there was $84 million in fraud that charter schools were perpetrating on the state of California. I sincerely regret that and will certainly check into where all that fraud is occurring. I also like to point out that the statement that there are no regularly scheduled audits of charter schools is perplexing. I suggest you ask the superintendent of public instruction whether any schools or school districts are audited, and he will tell you they all are. The controller audits them. We also have to do private audits that are shared with our school district authorizers. Our authorizers oversee our finances. To make those statements in support of this bill is really very surprising. And I really didn't want to talk about that, but those things had to be responded to. So I do want to get into what I do want to talk about. And that's two things. One is CCSA does agree that the law needs to be clarified. And we've made it very clear over many, many years that the law needs to be clarified. We support changes to the Public Records Act. We support changes to the Political Reform Act. We support changes to the Brown Act that include charter schools. The one thing that we don't agree with is Government Code 1090, and we've made it very clear from the beginning, for the last few years, that that is a real problem. It's become even more apparent to us how much of a problem. Charter schools do not have the same flexibility that school districts have in order to accommodate financial crises. And nothing illustrates this better than what school districts and charter schools recently went through relative to the deferral of payments that besieged us all during the recession. School districts had a lot more options to pursue in order to get through that period. The charter schools did not. We had to turn to our board members. We often had to turn to our founders and our staff just to keep the doors open. Under Government Code 1090, which is a meat cleaver approach to controlling conflict of interest, many of our charter schools may not have survived because they wouldn't have been able to turn to these people and ask for help because they were board members and they would be prohibited from helping. Or we'd have to say, we'll take your money, but you can no longer be on our board. We're simply asking that a provision of the law that is so draconian when it comes to an organization like a charter school needs to be excluded from this proposal. I will say, and many of you are new, and many of you have not heard this before, and I hope that you don't have to hear it as many times as we have had to hear it. But the reality is, this is an issue that has been down this road several times. This is an issue that the governor has made clear in 2011 with AB 360. Last year with AB 913, that he's not interested in seeing a bill with Government Code 1090 in it. We have said from the beginning that if we collectively, CTA and AXA and CSBA and all the other organizations, grab hands and walk down to the governor's office with a deal that we can all support, we believe we can finally convince the governor to make some changes in governance and conflict of interest that will serve everybody and serve everybody well. And we would encourage this committee at some point, if it's not today, later in the process, to allow us all to do that, put 1090 aside, keep three-quarters of the bill and move it forward to the governor's office and get a signature. Thank you.
Thank you. Any questions or comments from the committee? Ms. Weber?
Yes, I want to thank Mr. Gibson and those who've brought the bill forward, and I support the vast majority of this bill because charter schools are public schools and should abide by the same basically transparency rules that everyone else in terms of the Brown Act and the meetings and so forth and so on, and those kinds of things are critical. I do think it is important that we have to look at the 1090 aspect of it. I'm going to support this bill today, but as we go forward, I'd love to, it's not a commitment to voting for it on the floor, because we do have to look at the 1090 provision, and many of the charters in our districts do have supporters and individuals who are founders who help finance the school. They don't get any money out of it, but they help with the school and they help to get the thing, keep the school going. You know, we've got a lot of charters that have support. They're not profit-making entities as such as sometimes folks think, and so it becomes difficult to do that. And I know the governor is not in favor of 1090 being in a bill. We've done this every year that I've been here. We've had this bill come forward, and while we do like the aspects of transparency, we do like the aspect of making sure we have the Brown Act covered and things are done in the open and there's adequate auditing and so forth and so on. We all are in favor of that, but it becomes difficult because of the challenge of running charter schools, and I've seen charter schools that have not had support of individuals to step in, and those charter schools have failed, and yet they were providing a good service in the community but didn't have major benefactors or someone who could help in difficult times, as we've seen in the last 3 or 4 years. So it's a good concept. I think no one believes that there should be fraud, those kinds of things that are there. And even with the issue, I'm not sure if there's that much fraud in charter schools. Maybe there is. I've not seen that much before. But so it made it kind of strange to accept it, but even if it's $1 of fraud, it's too much fraud. I mean, so I'm not going to quibble about 80 million or whether it's 1 million. Any fraud with public dollars is unacceptable. But I think we also have to be fair and look at the 1090 rule, and it is a significant piece in this, and it kind of takes us away from the transparency piece that we really want to get at, to make sure that what's happening in charters is open for those to see, open for the public to attend. It's public dollars, so they can come to the meetings. They should be able to speak at the meetings. They should have the same rights that you have as before school board. And so I would strongly, I'm supporting this bill today, but I strongly recommend to the author that you look at the 1090 aspect of it if you want the bill to be successful as it sails through both houses and gets to the governor's desk.
Thank you. Mr. Thurman.
Thank you. Quick question, Mr. Rand. Thank you for your testimony. I'm glad that you clarified about the question of audits, because I've visited many charter schools, and a lot of them are nonprofits, and I know that they're required to do an audit, and so that made complete sense. And I'll support this bill because I see the nexus between public funding in public schools and public accountability, and that's it. This is not about fraud, but if there is fraud, it should be addressed. What I don't understand completely, though, sir, is the concern about 1090, and I was hoping that you could share with me what that is. Now, I've been very impressed by the ability of many charter schools to do fundraising to supplement the kinds of things that schools need. To me, it's been very similar in some ways to how some schools in our traditional public schools have these great parent clubs and PTAs that do great fundraising. Now, granted, some of these charter schools have individuals whose individual ability to give outweighs what all the parents in a lot of our schools can give. Having said that, I think that these schools are doing what they should. They have the ability to raise money in an environment where, we don't give our kids enough money through ADA. We should, in this state, give more. And because we don't, I get it. These schools raise money. What I don't get is your concern about 1090, and if you could just be explicit, because as I read 1090, it just says that no person who's affiliated on a board or a school or in a public capacity should benefit from a contract. That sort of language is what I read. And so I'm just wanting to understand what it is that is a concern for you and those you represent about 1090.
Sure. Mr. Thurman, thank you for the question, and hopefully I can explain this concisely. First, please understand that 1090 is an absolute statute. There is no wiggle room. There is no recusal, not even a question of whether you benefit or not. If you are on the board of directors, you cannot engage in any financial interaction with the organization on whose governing board you sit.
Does that include making a contribution to the school?
Does not include contributions.
Okay, I just
so
wanted
you could make a donation.
Okay,
yeah.
all right, go ahead. Continue,
Absolutely.
Please.
So charter schools, unlike school districts, often depend, especially during their opening phases, depend on the benefits provided by founders, by board members, people who are committed to making sure that the charter school is open and run successfully and can keep the doors open. And that's not always a whole lot of people. Some charter schools may do really well in the long run relative to fundraising, but early on, and also in periods of recession like we recently experienced, we often turn to people who are so passionate about the school that they have committed themselves not only financially, but also to its governance. And so when you have somebody who's willing to step up and, for example, provide a better than market rate on a facility that he or she owns that could be used for the charter school, could even arrange a lease that's at zero. It's still a lease, and it's still a contract. And so while the charter school may be paying little or nothing for that facility, the person offering that could not sit on the board of directors and offer it, even if it's $0.
Can I ask a question there? Mm-hmm. When I served on the board, I was always told that the measure was there's a conflict of interest if you can show that there's a financial benefit to you. And I just want to be clear, because in the example that you gave, if the lease is zero, then the property owner and donor would not be gaining any financial benefit. I guess I'd be concerned if 1090 prohibits that. I'd be concerned with you if that would be prohibited. And do you have information that it would be prohibited?
Certainly not with me, but we can certainly
Okay.
share that with you, and,
Okay.
and would certainly defer to Ledge Counsel if Ledge Counsel has an opinion on that provision of the law as well. I hate to put you on the spot.
No, you
So
should.
sorry.
Yeah. We got lawyers in the room. Put them on the spot.
Good afternoon, members of the committee. It's Christine Marucci from Legislative Council. I'd be happy to look into that if, all right.
But just to be clear, our experience with it is it's very absolute, and it could be $0, but as long as a contract is involved, like a lease, it would apply.
Did you have other examples that you wanted me to hear? I mean, that was helpful, but if you have others, I didn't want to.
Well, there's the deferral issue. We had members sitting on the board of directors who actually loaned money, sometimes at zero or a very, very low rate, in order to get them through, and that was, there's a real help to many charter schools.
I see. Thank you, sir.
Thank you, Mr. Thurman. I think one of the points, though, is without 1090, 49% of the board could have a financial interest in the organization. So I think that's where the concern comes in.
Well,
We sat down this morning, and I heard your concerns, and I don't know how, we can't work this out today.
Right.
And I certainly listened to you this morning. I don't know how that gets worked out. I mean, I was on a city council. I couldn't lease the city property. Right, that's a slippery slope. I think that's the problem that we see. If you want to respond to that, go ahead.
I appreciate that, and you're absolutely right. We can't work it out in committee this afternoon, and look forward to talking. And again, most of you have not been down this path before, so you haven't had the experience of talking about this like Dr. Weber has many times in the past. So what you're referring to in the 49% is the Corporations Code, and because most of our charter schools are incorporated as nonprofits, they are governed by the Corporations Code. The 49% is a threshold beyond which you cannot go in terms of financially interested parties, meaning, for example, teachers sitting on a board of directors, people who are employed by the corporation. It still does not mean that you can engage in a contractual relationship in which you have a conflict of interest. The Corporations Code is abundantly clear about conflict of interest, and if you have a conflict of interest, this is the big difference with 1090. Under the Corporations Code, you can actually recuse yourself from the vote. If you can still have a contractual relationship, but you can recuse yourself. You cannot influence the other members of the corporate governing body, but you don't have to relinquish your role as a member of that governing body.
Mr. Chair, can I correct something?
One moment. Let me just. I've got one or two more questions. Is it Kyle? I didn't get your last name, and I apologize.
Surratt.
Thank you. So, what kind of audits and oversight are charters subject to, given your expertise?
So, charter schools in California, and same as almost every charter school in the United States, are subject to financial statement audits. So every single year, California's charter schools have to do an audit in that form. But colloquially, there's a lot of different types of audits that are out there, but we all just call it audit, right? Things like Enron happen when you just do a certain type of audit, but you don't do the type of audit that would uncover things like fraud, waste, and abuse, right? So the type of audit that would uncover fraud, waste, and abuse is one of which looks at internal controls. And that's not a very different type of audit, but it is substantially different because it carries a purpose to look inside of internal controls in a comprehensive way, whereas the financial statement audits that currently exist within California statute don't require an opinion on the internal controls of charter schools. So every charter school gets an audit. In our opinion, it's inadequate to really unearth the types of fraud internal control cases that exist. That's why we're able to see cases of fraud that go on for years and years and years with clean audits every single time that don't show fraud.
Well, are other states doing a better job than California?
Yeah, there are a few that are doing a better job. Take Pennsylvania, for example. The state comptroller there, every 5 years, does an internal control and external audit of every single charter school in that state. New York State does a very similar audit. So it's not just the audits that are conducted by that are ordered by charter schools themselves, but it's also a separate state regulatory body that goes in on a regular basis, as opposed to in California where they have to be requested, like FCMAT. If someone requests FCMAT to come in and do an extraordinary audit of charter schools in California, that's something that is totally possible, but they don't come in and do a regularly scheduled audit of California's 1,100 charter schools.
Thank you. And I think you wanted to comment.
I just wanted to speak briefly about the Charter Schools Association witness expressed that currently they fall under the Corporations Code with respect to this issue. And I would just assert that Government Code 1090 is applicable right now at charter schools. This bill is intended to clarify that, but that's part of why this is keyed non-fiscal, is because it's basically current law, and we're putting it in statute to eliminate any lack of clarity. We're trying to make it more clear.
Mr. Santiago.
Sure, thank you. Without repeating what my colleague from Oakland has mentioned regarding the inability from someone to participate, and I know we're not changing the bill now, but I'm hopeful that maybe with that portion of it could be take a look at and maybe try to come to a better conclusion on that portion of it. But thank you nonetheless for bringing this forward.
Ms. Weber.
Do you have evidence of this fraud, waste, and abuse? I get kind of concerned when we're sitting in a public meeting and I'm hearing this kind of language that's being used without evidence or substantiated evidence, or even saying that the audit we're doing won't reveal the fraud, waste, and abuse. So I'm trying to figure out how you found it out if the audit didn't review. I mean, it bothers me. The language is disconcerting. And I don't know if we need to have that much language about fraud, waste, and abuse unless we really do. And if we do, then my question is then who's supposed to be in charge, called the districts of these charters, who ought to be dealing with the fraud, waste, and abuse. And, the charter schools are one of the few schools that we have control over to the extent we can shut them down. And we do that. And so I'm thinking that if I were sitting on a school board and I had charters that had fraud, waste, and abuse on them, and that the first item on the agenda would be the elimination of those charters in my district. So I just caution us in the use of language as everybody listens, and it seems like we have this huge amount of fraud, waste, and abuse. Yet I haven't really seen a lot of evidence of it. Maybe we're not doing the kind of audit that would be much more helpful. Then I asked if we're doing the same kind of audit across the board for everybody, all schools, and so forth and so on. So as I listen, I kind of, get a little concerned because we can often toss around words that have some legal implications. Yes. And if we're knowledgeable of the $80-some million of fraud, waste, and abuse, I hope we have gone in and done something to eliminate this fraud, waste, and abuse in the system.
If I can answer.
I hope we have. Maybe we have. Yeah. I don't know. But I'm hoping that's the.
Yeah, so the Center for Popular Democracy, in addition to ACE and Public Advocates, released a report a few months ago, and we'll definitely connect your office with it, that documents every dollar of the $81.4 million that has been lost to fraud, waste, and abuse within the industry. And this report was a full analysis of the charter school law that was passed in 1992 and every single update that happened past that. So every single instance that we talk about has already been prosecuted.
Is most of it waste and abuse or fraud? Because those are different legal terms.
It is.
Because when you lump them all together, we have a lot of wasteful stuff here too.
Yes.
I mean, seriously.
It's all illegal activity.
So it's a difference between wastefulness and abuse and fraud, because there's some legal implications. That's why I'm trying to figure out if you lump them all together, the fraud piece could be rather small in terms of legal implications. So I'll see the document, but I'd be interested in seeing it because clearly those institutions or the school districts that have folks with that level of fraud, if that's much fraud is in there, I don't know, need to take some action on behalf of the citizens of California.
Yes, so we only use the legal definition of fraud, waste, and abuse, and so more than happy to talk with
Sounds good.
Your office about
Okay,
it.
Thank you.
Thank you. And seeing no further comment, Mr. Gibson, you may close.
Thank you very much, Mr. Chair and the committee. Let me just point out that most individuals that I see before me have served in elective capacity before, whether it's school board and or city council. And certainly we cannot vote, myself when I was on the city council, cannot vote on any particular item that came before the City Council that would financially benefit me. If so, that means I would have broken the law. And so certainly individuals who serve on companies and corporations that may be on the board of directors of a charter school should not be able to give contracts and things of that nature that would benefit their company or themselves personally. And so with 1090 being part of this bill, we welcome the conversation this bill move forward, but we respectfully ask for an aye vote.
No.
Thank you, Mr. Gibson. Do we have a motion? It's been moved and seconded. Madam Secretary, call the roll, please.
The motion is do pass. O'Donnell?
Aye.
O'Donnell, aye. Chavez? Kim? No. Kim, no. McCarty? Santiago? Aye. Santiago, aye. Thurmond? Aye. Thurmond, aye. Weber? Aye. Weber, aye. 4-1.
The bill is out 4-1. Thank you, Mr. Gibson.
Thank you.
Now go to patient Mr. Wilk.